Be seated, please. This is cause number 2020-0D02631, State of Texas versus Patrick Wood Crusius. We are here on some motions hearings. May we have announcements of council?
Good morning, Your Honor. Bill Hicks, John Davis, Rebecca Toronto. We're present and ready to proceed on behalf of the state of Texas.
Good morning, Your Honor. Mark Stevens, Felix Valenzuela, and Joe Spencer on behalf of Patrick Crusius, ready to proceed.
The record should reflect that the Court of Appeals handed down their orders yesterday afternoon. This court is going to proceed with this hearing in accordance with the rulings that have been made by the Court of Appeals. Mr. Stevens, well, let's take care of some matters. Is the county attorney here?
I'm here, Judge.
Are you here on the protective order?
No, sir. Protective order is probably the EHN attorney.
Your Honor, EHN is here. Gabriela Reed, on behalf of EHN, we are no longer under the county attorney's office. However, we are now separate through EHN. So Gabriela.
Are you here with regard to the motion to quash subpoena and for protective order?
Your Honor, I will make an appearance as such. Our understanding was the subpoena was, we were released under the subpoena based on the ruling from the appellate court.
Is that each party's understanding of yesterday's ruling? I thought the only thing keeping this case from going forward was any issue regarding the unsealed documents that this court unsealed last Thursday. I want to make sure, does either party still believe that the medical provider is still under subpoena for today's hearing?
Your Honor, our reading of the Eighth Court of Appeals order is that the only issues that we're not allowed to get into today are regarding the preservation of the surveillance videos.
Right.
And regarding the impermissible mental health and medical professional contact.
It does seem to cover this subpoena for today's hearing. Mr. Davis, is this?
My understanding is the same as Mr. Spencer's. That I would think that we would be, both sides would be prevented from putting on the mental health professional that was under subpoena and getting into that, at least leaving that area alone.
May the individuals that are here with regard to that subpoena or as attorneys for those people, may they be excused from these proceedings?
And Your Honor, so that the record is clear and my understanding is correct, are we talking about the subpoena for the nurse practitioner Weimer?
Yes.
That's our understanding.
Okay. And that's what you are here for?
Correct, Your Honor.
You may be needed at some points, but not today.
Thank you, Your Honor.
Thank you.
Appreciate it.
Let's deal with the state's motion to quash subpoena in part for unknown attorney believed to be John Briggs.
Thank you, Your Honor.
Mr. Davis, if I'm reading this correctly, first of all, we didn't know who the attorney was, but now you think we know who the attorney is.
That is correct, Your Honor.
And-
the reason being, if I can speak to that, is that the part of his proposed testimony would be on the Sixth Amendment issue, would be visitation logs that, since we found those, or Mr. Briggs found those in his office, that he would have to speak to that issue, and I think certainly the defendant is entitled to litigate his Sixth Amendment claim fully, and since it was Mr. Briggs that had those visitation logs in his, I think that's what the testimony will show.
My reading of your motion to quash is he can testify to all the stuff he's entitled to testify to, but
Yes.
should not testify to work product.
Work product, Your Honor, and anything that would not be material to defense of their client, I think, you know,
Not
getting
necessarily to the
into.
defense of their client. Mr. Briggs was in a previous administration and may have relevant evidence with regard to some of the allegations that the defense has made. It almost sounds like it's okay for him to testify under the subpoena as long as you're able to object to anything that may be work product, and I'm just trying
Work
to
product,
understand.
and also, there's some things I think they're just not going to be relevant, Your Honor. For instance, if they were to try to get into why he left the office, or what his lawsuit against the counties, all of it, things like that.
Well, those are absolute proper objections to make at that time, so I'm not going to quash the Mr. Unknown attorney, who we believe to be John Briggs's subpoena.
All right, Your Honor.
Let's take up the state's motion to quash the subpoena for Loretta Hewitt. Mr. Davis, you would agree with me that most motions to quash are filed by the individual who is subpoenaed who does not want to testify?
Correct, Your Honor, except for the fact that I think that the privilege to claim for work product is the state's privilege. It's
Right.
the district attorney's office privilege. So that's why we're filing the motion to quash here, because we think that certainly, I think the evidence would show that Ms. Hewitt released what she considered to be Brady material. She's released all of that, and since our understanding is that she has released all of that, she has nothing to testify to. There would not be work product.
You would agree with me, we would be both on the same page that exculpatory evidence would not be protected by work product?
That's correct.
Brady would not be protected by work product?
That's correct.
And allegations of prosecutorial misconduct would not be protected by work product?
Perhaps so, and certainly in the one instance that I believe the defense has alleged, as far as any agreements with state's witnesses concerning their testimony, and I think their allegation is there was an agreement with a possible agreement with a witness to decline an offense charge in exchange for testimony. I think that is something that would have to be disclosed, and I think that in addition to the Brady material that Ms. Hewitt has disclosed, she wrote a memo disclosing her understanding of what happened with the declination of an offense charge against a potential witness in this case, actually one of the victims in this case, and that she's already done that. So that our position is she has nothing left but work product.
Mr. Stevens, you stood up. Did you want to address this motion to quash?
We have no intention of getting into anything work product, neither does Ms. Hewitt, Your Honor. We think if they have objections to specific questions we ask or answers she gives, they should lodge them at that time, but not quash this subpoena.
The court is in agreement that these are objectionable, the proper response is objections at the time that the question is asked.
Your Honor, just so the record is clear, and I understand your prior ruling about not quashing the subpoena for Mr. Briggs. Just so the record is clear, Your Honor, we were told by the District Attorney's Office that some information was found in a lawyer's computer, as well as a paralegal's computer. And then, so we did not know who that lawyer or that paralegal was. So we issued a subpoena to both the unknown lawyer and the unknown paralegal. We have since come to find out, as we believe, it was Mr. Briggs's computer and Mr. Hernandez's computer. So I just wanted the record to be clear that that was the reason why the subpoena was issued in that format, because we were given information, but not given information who it was until later.
There is one other subpoena that I want to address. One of my deputies who's part of our security detail has been subpoenaed. Unless there's an objection, the court is going to not have him be part of the rule that may be invoked. Is there any issue from either side with regard to that?
Yeah, I believe that individual was subpoenaed by the state, Your Honor, and we did have some conversations. We are in agreement that he be exempt by the rule. And just as a matter of course, we would invoke the rule now, Your Honor.
With regard to that deputy, any concern by the state? He comes in and out. He's not necessarily in here at all times, but he may be in here
We
at
ask
some
that he be
point.
excused from the rule, Your Honor.
Mr. Briggs, the rule has been invoked. Is he going to be needed today, or is there any anticipation as to when he's going to be needed so that he can do?
We don't think so, Your Honor. We don't think we're gonna get to Mr. Briggs today. We don't know who else is in the courtroom that may have been part of the subpoena as well. So we will ask all witnesses that intend to testify that they be instructed if they're not aware about the rule.
I need all witnesses that have been subpoenaed and that believe that they will be testifying today to please step forward so that I can swear you in.
Your Honor, one other quick thing, can we ask that Mr. Briggs be excused from the rule? He's part of the prosecution team.
We're not in agreement to having Mr. Briggs excused from the rule, Your Honor.
Let's have the witnesses step forward, and if they're outside, let's have them step forward so they can be sworn in at this time. Do I change your contact information on my phone to unknown? Okay. Mr. Spencer, Mr. Stevens, Mr. Valenzuela, I was just handed subpoenas that were filed early this morning. Are there any other witnesses that you think are in the courtroom or maybe outside that you have subpoenaed so we can bring them in?
We don't believe there's anybody else from the.
We have two more witnesses that we're looking for that.
Okay. And if they're not here right now, just let me know if and when they come in. If they're here, that's fine, but if not, just let me know so they can be sworn in
All right.
at some point. Raise your right hands for me, please. Do you swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? For the record, I need to start with you. Can you please tell us your name, please?
Rowan Pearson,
Crystal Bowser,
Scott Romero,
Lorraine Hewitt.
John Patrick Briggs.
Ladies and gentlemen, you've been sworn in as witnesses in this case, and the rule has been invoked. What that means is that while one of you is in here testifying, the others need to remain outside of the courtroom. You are not to discuss your testimony with anyone except the attorneys that represent the state or the attorneys that represent the accused. You're not to remain within the hearing of anybody discussing their testimony. You're not to discuss your testimony among yourselves. Finally, you are not to monitor anything that's going on in this courtroom by way of any live stream, podcast, social media information. If you know of or hear of any violation of the court's instructions, you are to instruct the court immediately. Does everybody understand my instructions?
Yes, sir.
Yes, sir. Yes, Your Honor.
Yes. Yes, sir.
Deputy, you are exempt from the court, from the rule. You can come and go as part of your duties on this case. The rest of you, please remain outside of the courtroom until you're called as a witness in this case. Downstairs, yeah. Just Mr. Stevens, Mr. Spencer, Mr. Valenzuela. In the September hearing, the court discussed how we're going to proceed today. At some point, the suggestion, I think, by the court is, do we go down your motion for discovery one at a time and see where we're at? Or would you rather proceed today with witnesses at this time and at some point maybe do it this way over the course of the next couple of days?
We have one witness at least we'd like to put on this morning, Your Honor, because it would go to the, what we've come to call the omnibus motion.
Call your first witness.
Loretta Hewitt.
Ma'am, you have been sworn. Please be seated. Mondo, let's get the mic adjusted correctly. And sir, can I have your name and your relationship to this case?
Sure, Judge Cliff Jessup, I'm counsel for Ms. Hewitt, Judge.
Go ahead and sit right next to her if that's your desire. You have been sworn. For the record, I do need your name. I need you to spell your last name for us.
Loretta Hewitt, Hewitt.
Mr. Stevens, you may proceed.
Ms. Hewitt, are you presently licensed to practice law in Texas?
Yes,
When were you licensed?
May of 1997,
Where did you graduate from law school and when?
St. Mary's University School of Law in San Antonio, Texas, in December of 1996.
Are you presently employed?
Yes,
What do you do?
I'm an associate attorney at a local law firm.
Could you briefly describe your work history since graduating from law school in 1996?
Yes, I have been an intern at the DA's office in San Antonio during law school. When I passed the bar, they didn't have openings, so I went to Gregg County District Attorney for a short time until Bear County contacted me and said they wanted me back. I was there from 1997 through 2014. And then in 2016 through 2021, I was a criminal defense attorney in San Antonio and surrounding counties. I then went to the Tarrant County District Attorney's Office in 2022 and was there for approximately 9 months. And the Denton County District Attorney's Office after that for approximately 3 months until I came to El Paso District Attorney's Office in January of 2023.
By my count, that is that you've worked for 5 different district attorneys' offices in Texas. Would that be right?
Sounds right?
And so would you agree that by far the vast majority of your experience as a lawyer has been as an assistant district attorney?
Approximately 21 years.
And you also worked as a criminal defense lawyer for a brief period of time. Not that brief, really. What, 5 years? Okay. And you've had some experience as a civil practitioner.
Yes, for about 7 months.
What date were you hired to work for the El Paso County District Attorney's Office?
I was given the offer, I believe, at the end of December 2022, and I started work January 4th or 9th. I don't remember the exact date.
And when did you resign from the El Paso County District Attorney's Office?
November 20th of 2023.
So you worked for the El Paso County District Attorney for approximately how many months?
About 11 months.
What were your responsibilities while working for the El Paso County District Attorney?
I was the trial team chief on we refer to it as the Walmart shooting case, the case that we're here about today. Being the trial team chief, that included cleaning up what had been done under Ms. Rosales. That included making sure that all discovery had been turned over to the defense. interviewing witnesses, pre-trialing witnesses, meeting with families, all that's included in preparing a capital murder death penalty case. That's the main part of my responsibility.
And when you were hired, by the way, who was it? Who was the district attorney who hired you?
Bill Hicks.
When you were hired, were you told what your role would be, your specific role, other than what you've told us, I guess in the hierarchy of what you call the Walmart case?
That I would be making the decisions, the major decisions on the case, the trial decisions, that I would be supervising the other attorneys that were on the case, I would be making the strategy decisions, and I would be the first chair or the lead prosecutor in trial.
And is Mr. Bill Hicks the person that told you what your responsibilities would be?
Yes,
And while you were working, the 11 months you were working on this case, did you work on any other cases in the DA's office?
no, I wasn't permitted to because I was being paid under the grant for the Walmart case.
Ms. Hewitt, are you familiar with the toll-free ethics helpline for lawyers maintained by the State Bar of Texas?
Yes,
Did you consult with that ethics helpline prior to your appearance as a witness today, specifically in regard to that appearance?
yes.
And when did you do that, if you recall?
It was approximately 2 weeks ago.
And what questions did you have for the ethics helpline?
I had been subpoenaed to testify, so my concern was what am I allowed to testify about? What are my ethical responsibilities and obligations? What am I not allowed to testify about? And was there any kind of attorney-client relationship or confidentiality relationship between myself and the El Paso District Attorney's Office since I had left?
Let's start with that latter, any kind of attorney-client relationship with the district attorney's office.
There is no attorney-client relationship with the DA's office. My client, when I was a prosecutor, is the state of Texas and the citizens of El Paso County.
And is that what the helpline people told you specifically?
Yes,
And was that also your understanding of whether or not there is an attorney-client relationship with the district attorney?
that covered the attorney-client relationship, yes, and that I owe no duty to Bill Hicks.
Okay. Did the helpline tell you subjects you could talk about ethically and that you could not talk about, and what were those?
Yes, along with my duty as to my client, the state of Texas, I am to make sure that no harm comes to my client. My protection is for the state of Texas. And I can speak about anything that is asked me, with the exception of strategy that had occurred, strategy for the case that we had discussed as a team for the Walmart case. Everything else is, especially in a situation like this, is allowed to be discussed.
So I will do my best not to ask you any question that I shouldn't, but if you think I do, you can certainly point that out. Please do.
Okay.
And you have Mr. Jessup here, and he can also, if you feel like consulting with Mr. Jessup, Your Honor, would that be okay?
We just need to know about it so that the court will allow that.
Yes, thank you. And you know, or if maybe you don't know, you're here testifying that the state of Texas had filed a motion to quash your subpoena, your subpoena. You know that.
Yes.
And the judge essentially ruled that we would be doing that on a question-by-question basis. So you're allowed to testify.
Thank you.
Ms. Hewitt, at some time after starting to work on this case as a prosecutor, did you inquire within your office about recorded phone calls by the jail between Mr. Crusius and his family or friends?
I did.
Your Honor, I'm going to now object to work products. He's talking about conversations within, as I understood the question, within the DA's office with what would be other members of the office, lawyers, investigators. So I'm gonna urge that this is a privileged conversation that she's going to, and
I think the
should be
question-
under work product.
I think the question was with regard to recordings between the accused and family and friends at this point. No attorney, whether state or defense, has been mentioned at this time, so I'm going to overrule your objection.
I did, as part of my attempt to familiarize myself with the case, one of the things I wanted to know is if he had made jail phone calls to family or friends or colleagues, that have colleagues, family or friends.
And in your lengthy experience as a prosecutor, is that something prosecutors commonly do?
Yes.
And is there anything wrong with a prosecutor trying to determine if there are recorded conversations that do not involve an attorney-client relationship?
No, I've done it many times over the years.
So what did you learn about phone calls between Mr. Crusius and family or friends or non-lawyers?
That there were no recorded phone calls to anyone.
So you started in January of '23. Would that have conversation or that inquiry of yours been about that time shortly thereafter?
Yes.
Did there come a time when you discovered that there were, in fact, recorded phone calls between Mr. Crusius and his lawyers?
Yes.
Tell us, when was that, by the way? When did you make that discovery?
August 31st of 2023.
And tell us how you made that discovery.
Myself and Michael Williams and Rebecca Tarango were in our conference room working on various things and going through some DVDs and CDs that we had. Michael Williams came across a CD that he was attempting to play and let us know that, hey, we say they're phone calls. There was a log that indicated they were phone calls. We were all surprised at that because we were, at least I and Rebecca and Mike appeared to be surprised because we didn't have knowledge that he made phone calls. Michael Williams was not able to play them for some reason. They weren't playing on the computer. We looked at the log to see what the numbers were and realized if they were to 210 area code, which alerted us that I know that your phone number is a 210 area code, and I also know that the defendant's brother lived in San Antonio, so we didn't know who they belonged to. I pulled out my cell phone and looked at my contacts log and realized that the phone number matched your phone number.
Monsieur, do me a favor, just get that microphone a little bit closer to you. Thank you, thank you.
So when you saw it was my phone call between my phone and Mr. Crusius from the jail, what was your concern?
There were many concerns. I realized the seriousness of what was happening, so I told Mike to stop trying to play them and to take the CD or DVD, whichever it was. I think it was a CD, out of the computer. We had a brief discussion about what we needed to do. I went to try to find out try to locate Mr. Hicks. He wasn't in the office. So we decided, because...
Could I stop you just 1 minute? I'm sorry to interrupt, but you said you stopped. So did anybody among those three people who were in that room at the time, you, Mr. Williams, and Mr. Tarango, did any of y'all listen to any of the conversation?
No, we all recognized the seriousness of what was happening.
Okay. So you stopped, you took the DVD out,
Yes.
and you looked for Mr. Hicks.
Yes.
Why?
Because he's the district attorney and I wanted to keep him informed of what was happening.
Okay. Did you were able to talk to Mr. Hicks at that time?
No, he wasn't in the office.
Do you remember about what time of day this event happened when you all discovered the recorded phone call?
My best memory is that it was mid-morning. I know it was before lunch.
Now, having worked for district attorney's offices for 21 years, is it your experience that it's very common, in fact, it's extraordinary not to be the case, that the DA's office, I'm putting too many negatives in it, is it the usual situation in your experience for DA's offices to have some method of filtering calls so that you can determine which calls are properly discoverable by your office and which attorney-client calls are not?
Yes, in all of the district attorney's offices that I've worked under, mainly in San Antonio, we regularly requested the phone calls, but there was procedures in place by the jail to make sure that they did not release privileged or attorney-client or legal communications, whether it was through the mail or phone calls.
Is that something that's taken very seriously among prosecutors?
Very seriously.
So had you assumed up to that point in time that El Paso County had the same sort of common procedures in play?
Yes, it wasn't even a thought to me that they wouldn't be in place.
So you were surprised, I take it, on August 31st when you found yourself in possession of these phone calls.
Yes,
And you said you had a discussion about what to do among the three of you. What was the nature of that discussion?
we all knew that we needed to disclose to the defense right away, and I think that was, there wasn't too much of a discussion, and I got on the phone with you immediately to let you know that we had these phone calls, and then it progressed from there, the steps that we took.
So you and I talked on the phone, and you knew that I was actually in El Paso that day,
Yes,
and you knew that I talked to our team about what we thought should be done.
yes,
Okay. And so you said you looked for Mr. Hicks, and he was not available at that time.
yes,
So did you make a decision about what to do at that time?
yes.
What did you decide?
I decided that I needed to contact you, that it wasn't, that this issue was not one that needed to be that I needed to wait for Mr. Hicks. So I decided to contact you and talk with you about at least disclosing and how we were gonna turn this over to you.
Did you subsequently speak to Judge Medrano?
I did. Initially, I wanted to turn these things over to you and put it on the record, what was happening, so that there would be no disagreement about what had happened. So I came to the 409th. I asked to speak with Judge Medrano. He was available. I told him in very general terms, I didn't disclose what was happening, but I said we had discovered that we had items that we should not be in possession of, that I wanted to turn them over to the defense immediately on the record, and I asked if one of his court reporter or somebody could be available in the afternoon for us to facilitate that. He said yes, and then I went back upstairs.
Did you and I talk again?
We did. In my mind, I knew what I needed to do, but the immediate question was, do we turn over the original? Do we make a copy? How do we, since we're not putting this on the record now, how do we protect ourselves and show that we've done what we needed to do? So you were adamant that you wanted those calls immediately. You said, yes, we'll prepare a hand delivery slip for you to come pick it up. And you assured me that we would at some point put this on the record, what had happened. And then we got it ready for you, the original, and put it in an envelope and waited for you to pick it up.
And is it your memory that the DVD was picked up that day?
Yes, I took it out to the front. It was somebody from Mr. Valenzuela's office, I believe. I just don't remember who it was.
Mr. Valenzuela, meaning Felix Valenzuela, co-counsel in the case. Did you call the State Bar Ethics Helpline that day, August 31st?
I did.
And why?
Because I felt like we had done everything that we needed to do and done it properly, but I wanted to make sure, given the gravity of the situation. And if they had any suggestions of something else that we needed to do, I wanted to know that.
And did you feel like up until that point in time that you had done everything properly regarding that call?
Yes, and Mr. Williams and Mr. Rango also.
They agreed with that?
Yeah, we all were trying to do the right thing.
Okay. And did you conduct your own legal research also, in addition to calling the helpline?
I did.
And did that confirm your belief that you had, up to that point in time, everything had been done correctly, as far as you knew regarding the phone call? As far as you knew?
Yes. One of the issues, though, was that you also in that phone call had made it known a couple of times that you all wanted to know who had listened to those phone calls and how long they've been in our office. You wanted details about that.
And what was your response to that?
I would work on that.
And did you immediately get to work on that, do what you could do?
I did. I contacted our IT department, I guess you would call it, and wanted to see if they could tell me who had access. I wanted to learn how those calls came into our office, how long they'd been there, and who had accessed them through our portal system.
The name Raymond Cano, C-A-N-O, does that ring a bell?
It does.
Was he, go ahead.
He's one of the people in the IT department.
Did you communicate with Mr. Cano either by email or personally?
Yes.
And what did you ask him to do?
I wanted to ask him if he had the ability to access who had gone into the system, access the folder where those files, those calls were, and if he could tell me who had listened to those phone calls.
Now, did you also, and we'll talk about what Mr. Cano's response was, but did you also, on that same day, August 31st, eventually talk to Mr. Bill Higgs?
I did.
Tell us about that conversation.
It was after lunch. We had dealt with everything. We had let the court know that we no longer needed to put things on the record. The issue had been resolved. I sent a brief email to him, updating him with what had happened. Rebecca and Mike and I were in the conference room again, and he came and directed me to my office to speak with me.
What tone of voice did he use with you?
He was very angry.
What do you mean?
I could tell by his demeanor and the words and the shortness of his words that he was upset. And I could tell when we were in my office that he was upset.
What did he say?
That just as much as I wanted him to communicate with me about what was happening, he's the DA and I was to communicate with him about things like this.
Did you explain your position about what you thought about the urgency of the situation?
I believe I did.
Did you feel like, to this day, do you feel like you had the authority to make the decision you made?
I had the authority and I had the responsibility to do what I did.
You mentioned my request that you look into who called, who might have accessed the calls. So was your first effort to do that talking to Mr. Cano?
Yes.
And that again was on August 31st. What did you ask him to do?
I asked him, I didn't know if he had the capability to go into the system and discern who had, if anyone had accessed the phone calls, not just the file that they were contained in, but the actual phone call.
And did he send you an email the very next day responsive to your request?
Yes, and he included some charts or maybe an Excel spreadsheet, I don't remember exactly, indicating what he was able to determine regarding phone calls.
Do you recall exactly what he said to you?
Not the exact words, but he provided me a list of names of people who had accessed the folder in the system that contained those audio files. He was not able to tell me who, if anyone, had actually listened to the phone calls. So he gave me a list, maybe 5 people. I think there were 3 people that were still employed in the office, and some people that were no longer employed in the office that had accessed that folder, which contained.
So, tell me what that told you. It told you a number of people who had access to it. Mr.
Yes.
Cano could say that.
Yes.
But was he able to pinpoint, maybe you answered this, was he able to pinpoint anybody who specifically had listened to the calls?
No, I don't think that our computer system had the capability to give him that information.
So when did you get Mr. Cano's response, if you remember?
I believe it was the next morning.
Early the next morning at 9:01 a.m., does that sound about right?
Sounds about right.
What did you do? Did you forward that communication that you got from Mr. Cano that you just described to Mr. Hicks?
I believe I did. I believe I forwarded it to him. If I didn't actually forward the email to him, I sent him the information that I had learned from Mr. Connor.
May I approach Ms. Hewitt, Your Honor?
Yes, you may.
Let me show you to see if this refreshes your recollection. I have marked it for identification, Defendant's Exhibit Number 1. If you can just start at the back of that and just refresh your recollection, please.
Yes, I forwarded him the email from Ray Connor.
What did you say?
Let me know if you want me to inquire, yes, let me know if you want me to inquire of the people who access the audio portion of portal. Also, my recommendation is that we immediately remove the 4 phone calls from portal.
And how did Mr. Hicks respond to that?
He responded that we can meet about it this afternoon. Thank you. Please move to remove the recordings from the case portal.
Okay. So he said 2 things.
Yes.
Please remove the recordings from the case portal. Tell us what that means to remove it from the case portal.
We didn't want any of those phone calls to remain in the state's possession or the DA's office possession. So I asked Ray to delete them from the system.
So, whose portal was that? I'm sorry, bad question. District Attorney had a portal of some sort?
It's a portal that, and my limited understanding, the portal is, the defense attorneys or attorneys working on particular cases have access to the portal. It's where all of the documents, evidence, police reports, everything pertaining to a case is stored. There is a portion of the portal that the DA's office only has access to, and that's where we would keep our notes and work product and things like that. But the rest of the portal is where, like I said, the police reports, all the evidence is stored.
I don't know that I asked you this. How many phone calls did you discover on August 31st?
4.
4 recorded phone calls between lawyers and between my phone number and Mr. Crusius.
Yes,
Okay. And whether there are more than that, you don't know, do you?
I don't know.
I can tell you we just got some information today that you probably don't know about, but we'll bring that out about there being actually more phone calls than that.
Okay.
But that's what you found, 4, and it was so important that you were clear that's all you had on that DVD.
Yes.
Okay. So Mr. Hicks was in agreement, I take it that's what you wanted to, that the phone calls be removed from the portal,
Yes.
because you had given us a DVD.
Yes.
And so I guess at that point in time, as far as you knew, the DA's office didn't have any recorded phone calls left. You've given us the DVD and taken it off your portal.
Yes.
And that was your intent.
Yes.
And Mr. Hicks agreed with that suggestion, take it off the portal. What about, he said, we can meet, what did he say? We can meet this afternoon?
Something like that, yes.
Did he meet with you that afternoon?
No.
You have a specific memory that there was no meeting with Mr. Hicks on the afternoon of September 1st, 2023.
I don't have a memory of that.
Okay, okay. So, did ultimately your meetings or your conversations with Mr. Raymond Cano give you some idea about people in the office you might contact?
Yes,
Because you had said that too. You sent me, you sent our whole team, the defense team, an email on September 8th regarding the phone calls. You remember doing that?
yes,
And the last line in there, I'm still trying to determine who, if anyone, listened to the calls while they were in our office.
yes.
Did you feel like, this is 8 or 9 days after the discovery of the phone calls, did you feel like it was very important for you to do whatever you could do to find out who listened to those calls, if anybody?
Absolutely.
So from the lead Mr. Cano gave you, do you remember talking to several people within the DA's office trying to figure out if anybody had listened to those calls?
Yes, I did not receive a response from Bill about my question of whether or not I should follow up on it, so I decided to do that on my own.
And so would that be that you actually did the follow-up on or about September 19th, 2023?
Yes.
Who did you speak to, if you remember?
The first person I spoke with was Claudia Hernandez.
I'm going to get back to her.
Okay,
Tell us who else you spoke to.
I spoke with Ada Waneri.
Who was she?
She was I don't know if she's still in the office, she was a prosecutor who was on the Walmart case for a couple of months. She was on it before I came in the office and then a couple months after I left.
Why did you have the idea that she might have listened to the call?
Her name was on the list that I was given by Ray Cano, who had accessed that folder.
Okay. Were you ever able during the course of your investigation to discover how people in the DA's office had access to the folder that contained these files, these calls?
Well, before I came on the case, there was, I don't know if there were any restrictions on who could access the Walmart folder and file. After I came on, I tried to shut that down and lock it down and limit who had access to anything Walmart related. But I learned through my conversation with Claudia Hernandez how she had accessed those phone calls.
Okay, and I do want to get to there, but Ada Waneri said, how do you spell Ada's last name?
I don't.
We'll look it up.
It's a special.
Okay, okay. What did she tell you about whether she had listened to the calls?
I don't think she even knew there were phone calls. I remember her being surprised, and absolutely not, she had not listened to them.
Who else do you remember speaking to other than Claudia and Ada?
Madison Dingle,
And what was her role in the case and the office?
she was a paralegal and had been on the Walmart case for a brief time.
And what did she tell you about having listened or not?
She did not have knowledge of the phone calls as far as I know.
And did you speak to anybody else other than Claudia?
I did speak to someone I don't remember her name, and I don't know, she was in the audio visual unit, I don't know what it's called really. She was a non-attorney and part of the office when videos or some kind of audio evidence comes in, it goes through that office first, I guess, and they download things and put it up or upload into the correct case file.
So this person, you don't remember her name, but she was also an employee of the El Paso County District Attorney's Office.
Yes.
Now let's talk about Claudia Hernandez. You went to her because why?
Because her name was on the list that Ray Cano had given me.
And when I say you went to her, would this be September 19th, 2023?
Yes.
What did What did you ask Ms. Hernandez?
I asked her if she knew of any phone calls that had she ever listened, or did she know of any phone calls between the defendant and anyone?
And what did she remember?
She remembered, yes, that she was aware, she said 6 or 7 phone calls between the defendant and his attorneys.
Okay. What is GTL?
GTL, from my understanding, is the system that is run maybe by the jail, I believe. That's the system that records the phone calls and then provides the DA's office with access to those phone calls.
You said she thought she had listened to 6 or 7 phone calls
Yes,
between Mr. Crusius and his lawyers.
yes.
And did she tell you she knew right away that he was talking to his lawyers?
Yes, and when she said that, I told her, don't tell me what's in those phone calls or what you remember, and I asked, do you remember what was in those phone calls? And she said yes, and I said, you're not to tell me what was in those phone calls, and you're not to repeat to anyone in the office the content of those phone calls or even discuss the phone call.
Did I ask you what job Ms. Hernandez had in the DA's office?
She was a paralegal in the homicide unit, and she had done some work on the Walmart case.
So this employee of the district attorney's office said, yes, I listened to 6 or 7. I knew he was talking to his lawyers, and she listened anyway.
She did.
But you told her immediately, don't tell anybody, don't tell me, don't tell anybody.
Right.
Did Ms. Hernandez know whether anyone else had listened to phone calls in the office?
I don't think she knew of anyone else that had listened to them. I don't believe she told me of anyone else that had listened to them.
Do you remember having a communication or attempting a communication with Mr. Hicks on September 19th after your phone call with, after your meeting with Claudia Hernandez?
Yes, I sent an email to him. I'd had communication with him between September 1st and September 19th, but yes, I sent him an email on that day.
May I approach again, Your Honor?
Yes, you may.
Showing you again, defendant's exhibit number 1, and ask you to, if that refreshes your recollection, about exactly what you told Mr. Hicks on September the 19th.
Yes.
What did you say that particularly relates to this recorded phone call?
We haven't been told if we're going to have a Walmart meeting this week, and I want to put on your radar that the issue of the jail phone calls still hasn't been addressed. We need to put on the record how we discovered the calls and steps we took to disclose and remove them. Remember also that the defense wants to know who in our office has listened to the calls. There's not only the issue of people who access the audio page of Portal, but the unlimited access to the GTL jail phone call system. At least one of the paralegals still in our office has listened to the calls. I would not be surprised if defense doesn't bring this up on Monday.
So why did you want to put it on Mr. Hicks' radar about this recorded phone call?
Well, because it was a serious issue and we needed to address how we were going to let the court know and what we were going to put on the record. Also, I had, in between this time, done some research on the ramifications of the state coming across these phone calls, and I had told Mr. Hicks of what I had learned. I told him in passing in the hallway that I wanted to talk with him about this case that I had found that was very close to being on point, and some things that I thought he needed to do, some changes he needed to make to show that we had corrected the situation.
So you're meeting, or you're running into him in the hallway, Mr. Hicks, would that have been sometime between September 1 and September 19th,
Yes,
before you wrote the email?
yes.
And what did he say when you ran into him in the hallway about the case you wanted to bring to his attention?
I told him some of the general ideas in the case and some things that I had learned and some steps that he needed to take, and he said, we'll deal with that another time.
What did you think about that response?
I was concerned because it was something that needed to be dealt with, and I think it was important that we make the changes that the case law said, so that we could come to court and show the court that we had done what we needed to do, and we've made the changes so this didn't happen again.
And given your experience as a prosecutor, did you think his response was appropriately serious?
No,
And is that why you then sent the email on September 19th to put it on his radar?
yes,
And what was the follow-up from Mr. Hicks after your September 19th email to put it on his radar?
nothing.
To ask specifically, the defense wants to know who listened to the phone call? By the way, did you tell Mr. Hicks about somebody who you knew had listened to the phone call in his office, in that
Yes.
email?
Yes.
What did you say to Mr. Hicks about that?
At least one of the paralegals still in our office has listened to the calls.
And that was who?
Claudia Hernandez.
And you're saying Mr. Hicks didn't respond to this email at all?
Not that I remember,
When you told him one of our paralegals has listened to it?
no.
Did you ever receive any further feedback from Mr. Hicks regarding these recorded phone calls?
Not, not that I remember.
May I have just a minute, Your Honor?
Yes, sir.
Let's talk, Ms. Hewitt, about Allen, Texas, Dallas, Texas.
Okay.
Did there come a time when you and other employees in the El Paso County District Attorney's Office traveled to Dallas and then to Allen, Texas?
Yes,
And was your purpose to seek out and interview potential witnesses regarding this case, as you refer to it, the Walmart shooting case?
yes,
And that's the case involving Mr. Crusius, the state of Texas versus Patrick Crusius.
yes.
Do you remember the date that you traveled to Dallas and then to Allen?
We flew to Dallas on November 7th and returned to El Paso on November 9th.
You say we, who was the we?
Rebecca Tarango, Ray Sanchez, an investigator in the office, and Ms. Tarango's husband.
So Ray Sanchez, you said, was an investigator in this office for the El Paso County District Attorney.
Yes,
Did y'all travel to the neighborhood in Allen, Texas, where you believe Mr. Crusius had lived for a good part of his life?
yes.
Approximately how many potential witnesses did you and your colleagues interview?
My memory is 4 former neighbors and 1 fact witness who had been president of Walmart.
Okay, so that's 4 neighbors and 1 person, 5 total?
Yes,
And the one, the one of the victims lived in Dallas, actually, is that right?
yes.
Okay, so let's talk about the Allen witnesses, potential witnesses first. What was your methodology about locating those potential witnesses?
We first started We went to a home that my investigator, Ray Sanchez, he'd made contact with the person, and he had several conversations with her, and she was willing to speak with us, but then he'd lost contact with her. So we went to her home, I believe we went there first, and tried to knock on the door, and she didn't answer. And so we decided just to drive around the neighborhood. We knew some addresses of people, like we knew where another potential witness lived, or a former neighbor. We drove by that house. We weren't having any luck, so if we saw people that we thought might talk with us, Ray would ask them if they would talk with us. And we also put business cards on the homes around in the neighborhood.
And did you get any feedback from the business cards?
We got one call from the business cards.
So when you interviewed these people, the 4 people in Allen, were you taking contemporaneous notes?
Yes.
How many notes? What kind of a note taker are you generally, and what was your note taking philosophy in this case?
It's always been my practice to take voluminous notes. I tend to write down everything that's said. It helps me commit it to memory, and it also, sometimes it's complete sentences, sometimes it's just, if they're going too fast, it's just something that will jog my memory of what they told me.
Okay. Do you remember one of the witnesses being named John Litwin, Litwin?
He's the one who responded to the business card.
Okay. So you went to his home and sat down with him there?
He came outside and we spoke with him out on the sidewalk.
About how long did you spend with Mr. Litwin?
I would say about 20, 25 minutes.
And you're taking notes all along?
Yes,
You're talking about handwritten notes?
yes,
And on what kind of medium were you putting your notes on?
a notepad.
Did you bring a copy of the notepad, not the notepad, but a notepad that you commonly use?
Yes.
May I approach, Your Honor?
Yes, you may.
Ms. Hewitt, please identify Defendant's Exhibit 3.
This is the type of notepad that I like to use and that I used during all of the pre-trial, my note-taking time on this case.
Okay. So if the judge had that notepad, that's blank, right?
Yes,
Okay. If the judge had that notepad, he would be able to see what kind of the same type and with the same number of pages that you used that day in November of 2023.
yes.
Your Honor, we'll offer Defendant's Exhibit 3.
No objection.
For the purpose of this hearing only, Defense Exhibit 3 is admitted into evidence.
Could I leave it here with Ms. Hewitt if she needs it, Your Honor?
Yes, sir.
You said you took the notes because you thought that helps your memory, right?
Yes, always been my practice. When I write things down, it helps me commit it to memory.
Now, we're talking about a particular type of interview here, right? An interview of a potential witness?
Yes,
When you conduct those types of interviews, do you ever put what a prosecutor would call work product into those notes?
I no longer do that.
Okay, no longer, but how about, I said ever, you're right. How about going back to November, talking about this pretrial interview with Mr. Litwin and the other people in Allen? In those days, were you putting work product in your notes?
No, I I intentionally leave strategy and my personal opinion or my just analysis of the witness. I leave those kinds of things off of my notes.
And that's what you did when you interviewed Litwin and the others in Allen?
Yes,
No work product, no strategy, no personal thoughts in those notes?
correct.
So what exactly are you trying to capture in your notes?
Everything they tell me.
Okay. Did you keep copies of your notes, you yourself, of those notes of the interviews with potential witnesses after you left the El Paso County District Attorney's Office?
No,
Where were the notes that you put on that notepad like Defendant Exhibit 3 is? Where were those notes when you last saw them in the DA's office?
my best memory is that they were on a shelf that I had in my office.
A shelf in your office and the DA's office? And would you recognize your notes today that you took in Allen, Texas in November 23? Would you recognize those notes if you saw them today?
Yes,
You don't have copies of them, is that right?
correct.
Your Honor, at this time, we request that the court order the district attorney's office to produce those notes so that Ms. Hewitt can identify them.
Response, Mr. Davis?
Your Honor, whether the witness thinks that that's work product or not, her interview with potential witnesses is work product of the state. Now, if he wants to ask the question, do you remember anything in there that you thought was mitigating or exculpatory, can you tell us that? That's fine, that would be exempt from work product. But whether she thinks it's work product or not, she's out there and interviewing potential witnesses for this case. And when she says, I wrote down everything he said, that is absolutely work product under 3914. It's privileged. We would object to having to produce those in court, and I assume he's going to introduce it into evidence.
Mr. Davis, let's assume that the police did not interview these witnesses, which usually takes witness statements.
Correct.
And these were the only reports or statements made by the witness. Are you saying that in trial, you would not be required to turn over that statement to the defense before they cross-examined the witness?
That would be correct, Your Honor. If it's limited like she says, and it's just her talking to the witness, writing down what he said, all right, then that is totally, I've even got it cited in my reply. That's not a witness statement to be turned over under what we call the old Gaskin rule. It is not one that would be turned over. He'd have to, in other words, I suppose if she turned over the notepad to him and said, would you look at this please, sir, and then if it's correct, affix your signature, I might go with you then that it would be a witness statement.
Okay,
But her just taking
let's
notes.
go there, let's go there. It's turned over to the defense before cross-examination, and it's shown to the witness who adopts it as his statement. You're not saying that at that point, it would be okay to turn over that to the state, to the defense?
You mean
an
you're-
adoption?
You're gonna ask the witness to read it and adopt it
To himself,
at
to
that
himself,
point?
yeah.
I don't really see how at that point, Your Honor. It seems like to me it would be his witness statement if he had adopted it while he was out there on the street or
Let-
something like that.
Let's go back a little bit. Do you
But I
have,
don't think he has adopted it at this point.
do you have the notepad? Let's go there. Do you have the notepad? And is it easily accessible to the state?
Can you give me just a
Yeah.
minute?
Mhm.
We have found no such notepad, Your Honor.
That's the state's position at this point. That you had, that there is no notepad. Can I order the state to continue to look for this, and in the event they find it, to bring it to the defense attention and at the appropriate time to the court's attention? That
Absolutely.
continuing duty.
Absolutely, Your Honor.
Okay.
I think we do continue to look for it, And under the court's instruction, we will continue to look for it.
I got that.
Go on, Mr. Stevens.
Your Honor, I just say I don't agree with Mr. Davis's interpretation that there are two separate things. The Gaskin rule, which.
Sure, I understand. You know, we had the legal argument that apparently we can have it a later time if we find that notepad.
Sure.
I haven't ruled that he's right or wrong. It's just that we don't have it at this point, and if and when we do, I know we'll talk about 3914 and Gaskin again.
And by the way, Ms. Hewitt, we're talking about one pad, but tell us, and we're going to talk about the different interviews you did in connection with this case, but tell us what your estimate of the number of notepads of the same size as Defendant's Exhibit Number 3 that you actually filled up with your notes, your pre-interview notes. How many?
5 to 6.
5 to 6 notepads filled up, just like the blank Defendant's Exhibit Number 3 is, of that size.
Correct.
Same
And those-
understanding, State, about looking for 5 to 6 notepads, same continuing obligation?
Yes, Your Honor, we will
Thank-
continue to look for any notepads, any notepads or any notes that we can find with Ms. Hewitt's handwriting.
Thank you.
Now, by the way, your last memory is those notepads were in your office.
Yes.
Who was Ron Banerjee?
He was he was an attorney assigned as the appellate attorney to the Walmart case.
And he passed away.
Yes.
Do you know what actions the district attorney's office took when Mr. Banerjee passed away to find what was on his computer and in his office?
They searched his computer.
And downloaded it?
Yes.
Okay. And he was also a lawyer who worked on this case.
Yes.
Did you hide those notes in your office?
No.
Be easy to find if they looked?
It was a little messy, but yes.
Okay. How big is your office? Was your office?
No. It wasn't large.
Not a large office.
No.
Okay, okay. I guess what I'm getting at, because I know Messi myself, but it wouldn't have been hard, given Messi, it wouldn't have been hard to find your notes for somebody who was looking for them.
Correct.
Now, who else among people at the Allen meetings were taking notes in the district attorney's office?
At the Allen meetings, Ms. Tarango, I believe she took some notes. She's not as much of a note taker as I am.
And how about Mr. Sanchez, Investigator Sanchez?
No, he was there more for protection and safety.
Now, you heard Mr. Davis's objection. I want to ask you about your take on that. What is your position about, in your practice, what your disclosure position is regarding the handwritten notes you take when interviewing witnesses?
The reason I said that I answered the way I did a couple of questions ago, I didn't used to turn over my notes to the defense. That's not something that's a common practice amongst prosecutors. It was not until I went to Tarrant County that it is their policy, not their policy, but most of the prosecutors in Tarrant County turn over their notes to the defense. I was hesitant about doing that at first because that's an uncomfortable position, because you have to be careful of what you have to be careful that you don't put your personal impressions or your strategy or what can be considered work product in those notes. I did that in Tarrant County and found it to be extremely beneficial, and it is now my policy to do that, and it was since Tarrant County, to turn over my notes. The reason being that we have all the concerns with 3914, with Brady, with Michael Morton. We also have a case that I had to argue in Fort Worth called Watkins that deals with what prosecutors are required to turn over, and that in my opinion, greatly expands what prosecutors are required to turn over, and it includes things, the term that's used a lot is material. And there's not a good definition from a prosecutor's perspective of what material is. It talks about what may be relevant, but what's relevant and what may be material can be disagreed upon between defense and prosecutor. So the idea that I learned from Tarrant County and that I continued on through El Paso was that you don't put work product in there, you don't put strategy, you put everything that the witness tells you, and then you turn those over to the defense, because if there is something that you have forgotten, that maybe you didn't believe was Brady or Michael Morton, or you may have a disagreement about what's in Watkins, you have, in an abundance of caution, turned over your notes, so you have disclosed to the defense. That actually happened in one of the murder trials I tried in Fort Worth, where I had turned over my notes, and the defense brought up in the middle of trial, hey, you haven't disclosed this. I didn't believe it was something I needed to disclose, but I pointed out, yes, I have, because it's in the notes that I gave you on this date, and that resolved the issue from the prosecutor's perspective.
So that would have prevented that issue from being reversible error in the event of a conviction,
Correct.
and that would have ensured that the defendant got the full benefit of, let's talk about that. You mentioned Michael Morton, that's the Michael Morton Act,
Yes.
codified in 3914A, et cetera, of the Texas Code of Criminal Procedure.
I know it's codified, I
Okay.
don't know exactly.
Fair enough.
I know 39.
Sure. And you're aware, Brady v. Maryland is a separate constitutional requirement also.
Correct.
3914H is the expansion of Brady within the Michael Morton Act,
Yes.
okay? And then additionally, we have, I think it's Article or Section 3.09 of the Texas Rules of Disciplinary Professional Responsibility.
I couldn't quote that for you, but I
It-
generally know the requirements.
Yeah, I couldn't quote it either, except you know, we both know, do we not, that imposes a separate ethical duty on a prosecutor
Yes.
to disclose mitigating,
Yes.
exculpatory,
Impeachable.
and impeachment evidence. Okay. So when you were taking your notes here, you were careful not to put in work product,
Correct.
and it was your intent to disclose those to the defense at the appropriate time.
I made that well known.
And you say, well known, did you talk to your colleagues about that?
Yes.
Ms. Tarango, what was her attitude?
She was not, I don't believe she was going to do that.
Okay. But you were,
Yes.
and you were the lead prosecutor in the case.
Yes.
So during your years as a prosecutor, are you familiar with those words we use and what they mean? Exculpatory evidence,
Yes.
okay? Mitigating evidence,
Yes.
and impeachment evidence.
Yes.
So with regard to Mr. Litwin, let's take him. Do you believe that the notes of Mr. Litwin contained evidence that a defense lawyer and a court would regard as mitigating?
Yes.
Anything come to mind? Now, I realize you don't have your notes in front of you to refresh your memory, right? But what can you remember that Litwin told you that you thought of that would be mitigating, and you would be compelled to turn that over to the defense?
Which I don't know if that's something I should answer.
I'll move along. If we ever find the notes, but you can tell us that you're certain in your mind that the notes, the information that Litwin was giving you contained mitigating evidence.
Yes.
Exculpatory evidence?
Yes.
And Ms. Tarango, was she also taking notes at this time?
Again, I taking notes. She, like I said, is not as much of a note taker as I am.
I'll ask you the same thing about just materiality. Do you believe that Litwin's interview disclosed material evidence that you had an obligation under Texas law to turn over?
Yes.
Let's ask the same question about witnesses who I don't even know their names. Do you remember the names of any of the other people you talked to in Allen?
In Allen, no.
Okay. Do you have any memory? Your notes would tell us that because they were voluminous notes.
Correct.
Do you have any memory, not having those notes in front of you, about what the other three people told you in Allen? Would that be mitigating also?
Some of it, yes.
Some of the things that those witnesses told you would be mitigating,
Yes.
and therefore something you had to disclose to the defense lawyers.
Yes.
How about material?
Yes.
Same question about the three other witnesses. Exculpatory.
I don't know that it would be exculpatory.
Okay, fair enough.
But I really need to look at it to be certain about that.
Sure. Well, let's say just hypothetically, if something was probative about a person's mental capabilities,
Yes.
could that be exculpatory in the right case?
Yes.
Okay. So I'll ask you just generally the same about not Litwin now, but the other three people you interviewed. You took notes of the same sort you've already testified about.
Yes.
You don't know where those notes are.
No.
The last time you saw them, they were in your office.
Yes.
Okay. And recorded on that notepad, like that you have.
Yes.
Let's talk a little bit about the Dallas visit. Was that with a person who was actually a victim of the shooting?
Yes.
And did you take notes during your interview of that gentleman?
Yes.
And is that Mr. Grant,
Yes.
Christopher Grant?
Yes.
Was Ms. Tarango also taking notes? Mr. Sanchez, either one of them, both of them?
Again, Mr. Sanchez didn't, I don't remember him taking notes, and he did not. Ms. Tarango, I believe, was taking limited notes.
Okay. And you took your typical voluminous notes
Yes.
of Grant. Now, is your memory that your interview of Mr. Grant, how long did that last?
Maybe an hour.
And during that hour, you were taking your notes. Do you remember things that you would consider as mitigating based on what Mr. Grant told you?
I don't know that it would be mitigating.
Okay. How about, let's go to impeachment.
Yes.
Okay. Did Mr. Grant say a number of things during that hour that you would think any defense lawyer, competent defense lawyer, would want to have available to consider for impeachment if Mr. Grant testifies?
Yes.
Anything material in what Mr. Grant told you during his interview
Yes.
that you made notes of?
Yes.
And same thing, you intended to turn your notes over, just like you said, that you recorded for Mr. Grant. You were going to turn those over to the defense if you'd stayed on the case.
Yes.
Did you and another person from the district attorney's office travel to Florida at some point in time to visit with the witness, Karen Kurth, Kurth? I'm sorry. So who was with you then?
Ray Sanchez again and Michael Williams.
Were you taking a lot of notes?
Yes.
Same type of notes, that's your standard practice.
Yes.
On the notepad like Defendant's Exhibit 3.
Correct.
And was Mike Williams taking notes?
He was.
Did he take a lot of notes?
He took more than Mr. Ray takes.
Okay. Mr. Rango was not present in the Florida visit, though.
Correct.
But Ray Sanchez was.
Yes,
Do you recall seeing him take notes, Ray Sanchez?
no,
Now, was Ms. Kurth somebody who had known Mr. Crusius from living near him in Allen, Texas?
yes,
Did your contemporaneous voluminous notes contain information that you believe to be mitigating
yes,
material?
yes,
Your intent was to turn them over to the defense?
yes,
Do you feel like they would be required to be, the information in those notes would be required to be turned over to the defense
yes,
because they were mitigating in material?
yes,
Same question, did you have those notes? You didn't take those notes with you?
no,
Last time you saw them, they were in the district attorney's office.
yes.
Your Honor, we just add that, I don't know that I did it specifically, to our request that they search for the notes regarding that witness.
Understood and agreed to, Your Honor.
Thank you, Mr. Davis.
Did you conduct pretrial interviews of the surviving victims, some of them, and members of the families of the victims in this
Yes.
case? Approximately how many people did you interview that would fit into those categories, survivors or family members?
I divided those those meetings into two categories. I would say a total probably about 30.
You said two categories. What did you mean by that?
I met with some family members and surviving family members when I first was brought onto the case, not in a pretrial capacity, but in a, I want to introduce myself, I want to let you know how we're going to handle this case, let them try to instill some confidence in them that things were going to go a different way than they had in the past.
Would you call that like more a meet and greet than a pretrial interview?
Yes, I don't take notes during those.
No notes. Okay. But the second category, the interview with approximately 30 people.
Maybe I wasn't clear on that. Between those two types of interviews, it was probably about 30. Some of the surviving family members didn't want to come in and meet with the DA's office again. So the ones that wanted to would come in. Then the ones that I consider them pre-trials, where we're talking about the facts of the case, and I am taking notes, probably about 20
Okay.
of those people.
So thank you for that correction. About 20 people you interviewed
Yes,
as what you considered a pretrial interview,
yes,
where you were taking the same kind of notes that you've talked about, voluminous,
yes,
trying to write down everything they said
yes,
on that notepad like Defendant's Exhibit 3?
yes.
And was that one of whatever, do you remember how many notepads those pretrial interviews comprised?
All of the, I remember 5 to 6 total notepads.
So that would include the Allen, Texas,
Yes,
the Dallas, Texas, the Florida with Kurth,
yes,
the pretrial interviews with the family members and the victims,
yes,
and also what we'll talk about in a minute, law enforcement.
yes,
Okay, so those were the 5 or 6 notebooks.
correct.
Did you, when you're talking to the family members, did you keep work product strategy out of those notes?
Yes,
Did those notes involving those 20 or so witnesses, did they contain evidence that you now believe to be mitigating?
they could.
Possibly. Some of them?
Yes.
Okay. We'd have to see the notes to know?
Mhm.
And you haven't seen the notes since you
No.
left them in the DA's office?
Correct.
Do you remember, though, that at least some of them contained mitigating evidence, those notes, your interviews?
Yes,
that is required by law to be given over to the defense.
Yes. I should clarify something on that. I guess it could be arguable whether it was mitigating or not.
Okay, sure. And sometimes defense lawyers see it differently than judges, than prosecutors.
Right.
And in that case, what's a prudent and ethical and law-abiding prosecutor to do?
I was trained from the time I was a new prosecutor that if you have a question or a doubt, you turn it over
To the defense.
to the defense.
And even if somebody were not as meticulous as you, would they turn it over at least to the judge
Yes,
in your situation? But you would have given it straight to the defense.
yes.
Did you see any harm to the state of Texas by doing that, by the procedure that you followed in every case?
No, it's only beneficial to the state to do that.
Beneficial, okay. I didn't ask you, when talking to the family members and the survivors, was Ron Banerjee present for a number of those interviews?
He was.
And we talked about what you know the DA's office did when he left the office, downloaded his computer.
Yes,
Did Mr. Banerjee take a lot of notes?
he did.
Did he sometimes memorialize his, how would he take notes from your memory?
You know, I don't remember specifically how he took notes, whether it was handwritten or if he used his computer, his laptop. But I know after one of our trips, and he had produced a summary of his notes and emailed those to myself and other attorneys on the case.
And in what form was that?
That he had typed, what was sent to me was a typed
Okay.
summary of them.
Okay, so it's your impression that he was taking notes contemporaneously, and that in addition, he summarized those notes?
Yes,
And again, you knew that the office downloaded his computer after he passed away.
yes.
Was Mike Williams there? Your meetings with the family members?
He came on, he was not there for the initial meet and greet type case, interviews because he wasn't in the office yet. He was there for, I want to say, every one of the pre-trials.
Do you remember him taking his usual, a lot of notes?
Yes,
Miss Durango was there?
yes,
Do you remember her taking notes?
yes.
And Ray Sanchez was at those meetings with the family and the survivors?
No, I didn't like to have an investigator
Okay.
or too many people in those interviews.
Okay. Same question about El Paso law enforcement. Approximately how many law enforcement officers connected with this case did you interview while you were in the office?
This is an estimate of my memory, maybe 75 to 100, could be more. I don't think it was less,
Were you taking notes in your usual fashion?
a lot of notes,
A lot of notes when you were interviewing the police officers?
yes.
Were the same assistant district attorneys present, Mr. Banerjee, Mr. Williams, Ms. Tarango, when those interviews were happening?
Yes, there may have been one interview or set of interviews that Mr. Williams missed. There may have been one that Ms. Tarango missed. But even if Ms. Tarango wasn't in the meeting, then Mr. Williams was also in the meeting with me. There were always two.
And before you met with those officers, did you try to sort of gather up the writings they had produced so you could talk to them intelligently?
Yes, I tried to gather their police reports and any handwritten notes that they had taken.
Did you have any particular problems doing that, gathering the necessary notes by the police officers?
I had difficulty gathering the handwritten notes, not the police reports.
Describe that, please.
Some police officers take handwritten notes, some don't. In El Paso, I believe that it's their practice to upload those with their report. The difficulty that I encountered was that I had a stack of handwritten notes that they hadn't signed their name, so I didn't know who they belonged to, and it was in disarray, so I couldn't determine who had written those notes and which police report they corresponded with. It's also, in my experience, very common for defense attorneys in trial or before trial to ask to have police officer notes turned over to them. And so I wanted to make sure that we had all of that before the pre-trials, but definitely before we actually went to trial. Inevitably, in my experience, there is something that an officer has put in a handwritten note that they've forgotten, or that can be helpful to the case.
Helpful to either side, I guess.
Either side.
And that's why you would turn over those notes as well
Yes,
to the defense.
yes, those were, the practice was to, in El Paso, to upload, or whatever, I don't know the exact process, but whatever was uploaded into the system and given to our portal was made available to the defense.
And you mentioned that some of the notes, it was important to try and correlate the handwritten notes, maybe that didn't have a name on them, with the particular officer.
Yes, because I wanted to, when I did the pretrial, I wanted to talk with them about what was in their notes.
And if you had to turn it over to the defense, you would want to turn over the right note that, as much as possible, was identified to a particular person.
Yes, and I wanted to know if somebody hadn't written notes, or if they had written notes but they hadn't been uploaded for some reason, where were they?
So you described the problem you were having. Who did you reach out to help you solve that problem?
I don't remember his rank or his name, but somebody, maybe a lieutenant over in El Paso Police Department, and asked him if he could send out a department-wide email to, I don't know if I asked him to send it to every officer or anybody related to the Walmart case, and ask them to reply whether they had their notes, if they did, whether they wrote notes, if they did and they had those notes, to resend them to me. If they no longer had those notes, to give me a brief explanation of why. It was not a problem, we just had to know why they didn't have them any longer.
So that particular higher up in the PD, was it?
Yes.
What response did you get from that? What help did you get from that person?
Well, they would, it's typical in this case that people would say, yes, we want to help you do anything, but there was also resistance in that might be a waste of time, because officers may just ignore that email.
Did you think it was a waste of time?
No.
Okay. So did you get the help you needed from the higher up person in PD?
No,
Who did you reach out to next?
Mr. Hicks.
And why and what?
Because I asked him to, if he could communicate with the chief's office and ask the chief or the chief's office to send out an email, because police officers aren't going to ignore something from the chief.
And what was Mr. Hicks' response to you?
He asked me to give him the language that I wanted to go in the email to the chief's office.
And did you do that?
I did, I sent it by email.
And what was Mr. Hicks' follow-up?
None that I'm aware of.
So you took your usual copious notes with the officers you pre-trialed?
Yes,
Did you say, what, 75 to 100? I'm not sure.
that's an estimate.
Okay. Where were those notes when you last saw them?
In my office.
Same, without repeating all the questions.
Yes.
Same thing happened to those notes, as far as you
Yes.
know. And do you believe those notes contained material evidence?
Yes,
Do you believe that some of the notes, anyway, contained exculpatory evidence or impeachment evidence? Let's do it one at a time. Impeachment,
possibly.
okay? Exculpatory.
I don't think any of them contained exculpatory.
Do you remember any of the officers ranting about anything?
Yes, there were some that, just a couple that had disagreements with how things were handled at the scene.
So do you believe those notes that you took pre-trialing the officer should be turned over to the defense?
Yes,
Did you also request that somebody in your office prepare or search for criminal records or disciplinary records regarding the law enforcement?
yes, the officer history.
Why?
Because again, that is something that is required to be turned over to the defense. It can be impeachment evidence. Mostly it's impeachment.
Tell us just briefly how a defense lawyer might use something like that for impeachment.
If an officer has been disciplined before for maybe falsifying a report or mishandling evidence, something like that, it could potentially be used against them when they testify in a preceding case.
Okay. So it's important information.
Yes,
And did you spend a lot of time trying to gather that information, you and colleagues in your office, and put it on the portal?
yes.
And what do you, how successful were you in accomplishing the mission you set for yourself?
I accomplished it, but it required a lot of work.
Okay. And then, so as of November of 2023, do you think that particular aspect was in good shape? That is, okay.
Yes.
The portal, but what about now? You don't have any idea now, I guess.
I don't. I had left the responsibility to follow up every 6 months, which is the timeline, 6 to 9 months that the DA's office uses to update the officer history information. I had assigned that to one of the paralegals that was on the case when I left. I don't know what's been done with it since.
Is there anything in the portal system that you know of that allows for or permits automatic updating?
My understanding is that, I don't want to misstate this because I don't have a good understanding of it. When an officer is entered into the system as being active on a case, my understanding was that it would automatically update in other cases that he's listed as active in. I didn't trust that that was happening based on the work that I had done to get the officer history disclosures in order.
Okay. Did you and some members of the DA's office visit with Timothy Fitzpatrick, the classification director of Texas Department of Criminal Justice?
Yes,
Approximately when?
I'm not certain about that.
Okay. July of '23?
Yes,
And who would be with you on that visit?
Mr. Hicks went, John Briggs went, Ray Sanchez met us halfway through, Ron Banerjee and myself.
Did you take your usual notes?
I took a lot of notes during that interview.
Did you notice what your colleagues were doing note-wise?
I know Mr. Banerjee was taking a lot of notes also. John Briggs may have taken some, but I'm not certain about that. I don't remember, I didn't pay attention to whether anyone else was taking notes.
And same questions about those. You don't have those notes?
Correct,
Last time you saw them, they were in the DA's office.
yes.
Your Honor, I've been told we have the notes on Fitzpatrick.
Do you have them here, or do you have them downstairs?
Downstairs.
Mr. Stevens, I know you're not done, and I hate ever interrupting, but can we go ahead and take a 15-minute break this morning?
Yes, Your Honor.
Before we take a 15-minute break, Ms. Hewitt, before I forget, I have a couple of questions. Ms. Hernandez, you told her not to tell anybody about, from that point forward, about the recorded conversations.
Yes, Your Honor.
Did you ask, or did she ever volunteer whether she had talked to anybody before that admonishment about the recorded conversations?
I But I did write a memo about that, and that would help me make certain.
You talked with, I'm gonna call him Ray in IT,
Yes,
and he indicated to you that maybe 5 people had access to that file.
that they had access to
Okay.
that file.
Is that from the entire time those recorded conversations were in the DA's office, or only from the time that this administration took over this case? Is it possible that lawyers in previous administrations had access to those recorded conversations that we're not able to identify because IT can't go back that far? I'm trying to figure out, are these 5, since the case has been in that,
In existence, I was able to determine when those phone calls had been uploaded into our system, and I don't have a memory of that, but it was a significant amount of time. They've been in our office, or that office, for
years?
years.
So his report is able to capture that only 5 people could have accessed that file during the entire time?
No, 5 people did access that folder. And I'm guessing at the 5, based on my memory. I know the 3, but I know there were people who had already left the office. Those were the people that we know had accessed it, but there were many more people that could have accessed it.
That's, I just wanted a better understanding. We're going to take a 15-minute break at this time.
All right, please.